Welcome to Divorces in North Carolina, Sandra Dinkins, defining the landscape fault versus no-fault divorce. Should states force spouses to show cause as to why they want to end their marriage? In the tapestry of human relationships, marriage holds a unique and often complex place. But what happens when this bond frays? Divorce offers a legal and emotional resolution to a marriage that has irretrievably broken down. Should states ban no-fault divorce? Fault divorce requires one spouse to prove the other's responsibility for the breakdown. No-fault divorce offers a less acrimonious path to legal separation. Couples can dissolve their marriage without assigning blame or proving misconduct. The debate continues, weighing individual rights against the sanctity of marriage. The heart of the matter: should states intervene? Should states dictate marital dissolution terms? Or should this decision rest solely with individuals? Advocates for fault-based divorce argue it preserves marriage's sanctity. They believe it encourages couples to work harder to salvage their relationships. Conversely, proponents of no-fault divorce emphasize individual autonomy. They argue the state shouldn't force unhappy couples to stay together. The debate is multifaceted, with valid arguments on both sides. The challenge lies in balancing these competing perspectives. A glimpse into the past: the evolution of divorce laws. Divorce laws have evolved significantly over time. Before the late 20th century, proving marital misconduct was necessary for divorce. Women often faced public humiliation to prove their case. California's no-fault divorce law in 1969 changed everything. It recognized irreconcilable differences as valid grounds for divorce. This shift reflected a broader societal transformation. Critics argue it undermines marriage and disadvantages women. Understanding this evolution helps us navigate current debates. The benefits of no-fault divorce. No-fault divorce marked a profound shift in marriage dissolution. It empowers individuals in unhappy or abusive marriages. Removing fault requirements makes separation less acrimonious. It allows ending marriages without airing painful details. Expedites the process, reducing emotional toll and costs. Beneficial for couples with children, fostering new family structures. Aligns with values of autonomy and self-determination. No-fault divorce offers a humane, pragmatic approach to modern relationships. Section 2. Navigating the shadows. The drawbacks of no-fault divorce. No-fault divorce has reshaped marriage dissolution but has critics. Critics say it undermines marriage sanctity, increasing divorce rates. They argue it makes it too easy to walk away without effort. Critics believe marriage is a societal cornerstone, vital for stability. No-fault divorce can disadvantage the less at-fault spouse. It treats both parties equally, removing potential redress. Critics argue it doesn't eliminate conflict, especially in custody and support issues. A balancing act, weighing individual rights and societal values. The debate on no-fault divorce centers on individual autonomy versus the sanctity of marriage. Proponents argue for freedom to end marriages without state interference. They believe staying in unhappy marriages violates self-determination. Opponents see marriage as a social institution with broader societal implications. They argue no-fault divorce undermines marital commitment and family stability. Balancing these perspectives is complex, requiring careful consideration of consequences. The road ahead: seeking solutions in a complex landscape. Navigating the no-fault divorce debate requires moving beyond polarized positions to address both sides' concerns. Instead of banning no-fault divorce, we should strengthen marriage and provide support during divorce. Promote premarital counseling and education for realistic expectations and strong communication. Expand access to affordable counseling and mediation services to support couples. Ensure a fair and equitable process for those who choose to divorce. Address financial vulnerabilities through enhanced spousal support and fair property division. Provide greater access to legal aid and resources to level the playing field. Prioritize the well-being of children affected by divorce. Promote co-parenting, access to counseling, and fair child support orders. A multifaceted approach recognizes individual autonomy, marriage's value, and protection for the vulnerable. Foster dialogue, promote healthy relationships, and ensure fairness in the divorce process. In the heart of the no-fault divorce debate, North Carolina stands as a compelling case study. It offers insights into how no-fault divorce laws function and their impact on families. Couples can dissolve marriages on irreconcilable differences without proving fault. This approach recognizes that marriages can break down for complex reasons. It prioritizes individual autonomy and acknowledges that prolonging a loveless union benefits no one. Despite no-fault grounds, behaviors like infidelity can impact settlements. North Carolina's system balances individual autonomy with fairness and accountability. While North Carolina embraces no-fault divorce, infidelity, though not a barrier to ending a marriage, casts a long shadow on alimony proceedings. Unlike some states where infidelity has no bearing on spousal support, North Carolina law allows courts to consider marital misconduct, including adultery, when determining alimony obligations. This provision reflects a recognition that infidelity can have significant financial and emotional consequences for the betrayed spouse. Imagine a scenario where one spouse depletes marital assets to pursue an extramarital affair, leaving the other spouse financially vulnerable upon divorce. In such cases, North Carolina courts may order the adulterous spouse to pay a greater share of alimony as a form of compensation for their financial misconduct. This approach serves as a deterrent to reckless or irresponsible behavior within the marriage, acknowledging that actions have consequences, even within a no-fault system. However, proving infidelity in court can be a complex and often emotionally charged endeavor. It may require presenting evidence such as emails, text messages, or eyewitness accounts, which can dredge up painful memories and exacerbate conflict between the divorcing spouses. Furthermore, the subjective nature of defining and proving infidelity raises concerns about fairness and consistency in its application. What constitutes infidelity in the eyes of the law? Can emotional infidelity be grounds for increased alimony? These questions highlight the challenges of incorporating fault-based considerations into a no-fault system. While North Carolina's approach attempts to balance individual autonomy with a measure of accountability, it also underscores the complexities and potential pitfalls of intertwining fault and no-fault principles in divorce proceedings. In matters of domestic violence, North Carolina's no-fault stance doesn't equate to a blind eye toward abuse. The state recognizes that domestic violence represents a serious breach of the marital contract and requires a distinct legal response, separate from the question of divorce itself. Victims of domestic violence in North Carolina can seek protection orders that prohibit abusers from contacting them, coming near their homes or workplaces, or possessing firearms. These orders provide immediate safety and security for victims, allowing them to escape dangerous situations and begin rebuilding their lives. Furthermore, North Carolina courts can consider domestic violence when making decisions about child custody and visitation. The law prioritizes the safety and well-being of children, and judges may limit or deny visitation rights to abusers deemed a threat to their children's physical or emotional well-being. This approach reflects a growing understanding of the devastating and long-lasting impact of domestic violence on children, even when they are not the direct targets of abuse. Furthermore, North Carolina law allows victims of domestic violence to file for divorce on fault-based grounds, even though the state generally operates under a no-fault system. This provision recognizes that domestic violence represents a fundamental violation of the marital contract and provides victims with a legal avenue to seek justice and accountability. By treating domestic violence as a separate legal issue with distinct consequences, North Carolina demonstrates that no-fault divorce does not equate to a free pass for abusers. The state's approach highlights how a no-fault system can coexist with robust legal protections for victims of domestic violence, ensuring that the pursuit of a divorce does not come at the expense of safety and justice. A case for personal choice. North Carolina's example. North Carolina's experience with no-fault divorce offers a compelling argument for prioritizing personal choice and individual autonomy in matters of marriage dissolution. By allowing couples to dissolve their marriages on the grounds of irreconcilable differences, the state acknowledges that the decision to end a marriage is deeply personal and should ultimately rest with the individuals involved. This approach empowers individuals to take control of their own lives and relationships, free from the stigma and scrutiny often associated with fault-based divorce proceedings. It recognizes that forcing individuals to remain in loveless, unfulfilling, or even harmful marriages serves no one's best interests, least of all any children involved. Furthermore, North Carolina's experience demonstrates that no-fault divorce does not necessarily lead to a surge in divorce rates, as some critics feared. While divorce rates did increase in the years following the adoption of no-fault laws, this trend was part of a broader societal shift that included changing attitudes towards marriage, increased female workforce participation, and greater access to education and economic opportunities for women. Moreover, North Carolina's approach shows that no-fault divorce can coexist with measures that address concerns about fairness, accountability, and the protection of vulnerable spouses and children. By allowing courts to consider factors such as infidelity and domestic violence when determining alimony, child custody, and property division, the state strives to ensure that the pursuit of a divorce does not become a license for financial exploitation or abuse. In conclusion, North Carolina's experience with no-fault divorce offers valuable lessons for other states grappling with this complex and often contentious issue. It suggests that a balanced approach that prioritizes individual autonomy while also addressing concerns about fairness and protection for vulnerable parties can provide a path forward that respects the dignity and rights of all involved. Reopening old wounds. The debate over banning no-fault divorce often hinges on proving fault to salvage marriages. This overlooks the emotional costs of reliving past hurts in court. Imagine a couple on the brink of divorce after years of pain. In a fault-based system, they must dredge up past grievances. This can escalate conflict and transform an amicable separation into a bitter battle. The courtroom becomes a battleground, replacing hope of a dignified resolution. Trapped in a broken system, the disadvantaged and the vulnerable. Fault-based divorce can harm the most disadvantaged, especially women and children. Proving fault is often insurmountable for those with limited resources. They may be trapped in unhappy or abusive marriages. Children suffer from exposure to parental conflict. Fault-based systems can use children as pawns, harming their well-being. This undermines the goal of creating a stable environment for children. The perils of proof subjectivity and the burden of evidence. Fault-based divorce is flawed due to the subjective nature of fault. Marital misconduct varies by perspective, cultural norms, and biases. Imagine a couple with irreconcilable religious differences. One sees it as betrayal, the other, a spiritual journey. Courts may delve into personal theological debates. Proving fault is costly, time-consuming, and intrusive. Spouses may hire investigators or hack accounts. This escalates conflict and creates distrust. The burden of proof often falls on the spouse seeking divorce. Emotional abuse and financial manipulation are hard to prove. Proving fault prolongs battles, increases costs, and undermines fairness. A step backwards. The potential for increased conflict and abuse. Fault-based divorce can lead to increased domestic violence and abuse. Abusers may escalate their behavior, knowing victims have limited options. The adversarial nature of fault-based divorce can exacerbate conflicts. This creates a toxic environment, especially harmful to children. Fault-based systems represent a step backwards, undermining well-being. Divorce in colonial America. Marriage was less about love and more about economic partnership and social stability. Divorce was rare, granted only in extreme circumstances. Marriage was seen as sacred, essential for order and morality. Whispers of divorce could ostracize a family. Divorce laws varied, reflecting diverse influences. In Puritan New England, adultery was often the only grounds for divorce. In the southern colonies, divorce was even more uncommon. Marriage consolidated wealth and power. Women faced social stigma and economic hardship. The seeds of change were already being sown. As America entered the 19th century, winds of change began to sweep across the nation, transforming not only its political and economic landscape, but also its social fabric, including the institution of marriage. The rise of industrialization and urbanization led to greater geographic mobility, fostering a sense of individualism that challenged traditional social structures. Marriage evolved to encompass the ideals of love, companionship, and personal fulfillment. Imagine a young couple in New York drawn together by shared dreams and emotional connection. This concept of companionate marriage, rooted in mutual affection and respect, gained acceptance among the middle class. As love and companionship became central, the notion that individuals in unhappy marriages deserved a path to escape emerged. This shift coincided with the rise of the women's rights movement, advocating for greater autonomy and equality for women. As the 19th century progressed, the debate over divorce intensified, reflecting a deeper societal struggle between traditional values and emerging ideals of individual liberty and personal happiness. States codified specific grounds for divorce, requiring proof of adultery, desertion, or cruelty. This fault-based system often trapped individuals in unhappy or abusive marriages. Victims, especially women, faced social ostracism and financial ruin. The stage was set for a dramatic shift in the legal and social landscape of divorce. The fight for no-fault divorce became deeply intertwined with the broader struggle for women's rights. As women gained greater independence, they they challenged patriarchal structures in marriage and divorce. The fault-based system often left women trapped in unhappy or abusive marriages. The feminist movement demanded legal reforms for greater autonomy and equality. No-fault divorce became a symbol of women's fight for control over their lives. The introduction of no-fault divorce marked a significant victory in the fight for gender equality. The shift to no-fault divorce coincided with broader societal transformations that reshaped the institution of marriage itself. The sexual revolution of the 1960s and 70s challenged traditional notions of love, sex, and relationships, leading to greater acceptance of premarital sex, cohabitation, and diverse family structures. The rise of the women's liberation movement further challenged traditional gender roles, as women entered the workforce in record numbers, pursued higher education, and demanded equal rights and opportunities. These societal shifts had a profound impact on how people viewed marriage. No longer seen solely as a pragmatic arrangement for economic security or social status, marriage increasingly became an aspirational goal, a symbol of love, companionship, and personal fulfillment. This evolving view of marriage influenced attitudes towards divorce. If marriage was no longer primarily about duty or obligation, but rather a choice made freely between two individuals, then it followed that individuals should also have the freedom to end those relationships when they no longer met their needs or aspirations. The introduction of no-fault divorce reflected this growing emphasis on individual autonomy and self-determination. It recognized that forcing individuals to remain in unhappy or unfulfilling marriages served no one's best interests, least of all the children involved. Furthermore, the stigma associated with divorce gradually diminished as society became more accepting of divorce as a natural, albeit often painful, part of life. While the institution of marriage continues to evolve, the shift to no-fault divorce marked a pivotal moment in its history, reflecting a growing recognition of the importance of individual happiness and fulfillment within marriage and beyond. Section 3. A question of balance, state intervention versus individual choice. The debate over no-fault divorce ultimately boils down to a fundamental question about the role of the state in regulating personal relationships. On one hand, proponents of state intervention argue that marriage, as a foundational social institution, deserves legal protections that promote its stability and discourage frivolous divorces. They contend that requiring proof of fault serves as a deterrent to reckless behavior, encourages couples to work harder to resolve their differences, and protects the innocent spouse from being unfairly disadvantaged in a divorce settlement. This perspective often reflects a belief that marriage is not simply a private contract between two individuals, but a public institution with broader implications for society as a whole. On the other hand, advocates for individual choice argue that the state has no business dictating the terms of personal relationships, particularly when it comes to matters of the heart. They contend that forcing individuals to remain in unhappy or unfulfilling marriages violates their fundamental right to self-determination and can have devastating emotional and psychological consequences. Furthermore, they argue that the fault-based system is often ineffective, easily manipulated, and disproportionately harms the most vulnerable members of society, particularly women and children. The challenge for lawmakers is to find a balance that respects both the societal significance of marriage and the individual rights of those who enter into it. This involves crafting divorce laws that provide a fair and accessible path to dissolution for those who need it, while also considering the potential impact on children and the economic well-being of both spouses. Ultimately, the question of whether and how to regulate divorce remains a complex and evolving one, reflecting changing societal norms, evolving views on marriage, and the enduring tension between individual liberty and the common good. Section 4. Navigating the future, challenges and opportunities. As we look to the future of divorce law, several challenges and opportunities present themselves. The rise of cohabitation, same-sex marriage, and blended families continues to reshape the legal and social landscape of marriage and divorce, requiring lawmakers to adapt existing laws and create new frameworks to address the unique needs of these evolving family structures. The increasing prevalence of online dating and social media also presents new challenges, as infidelity, online harassment, and the complexities of digital communication blur the lines of what constitutes marital misconduct and complicate the process of proving fault. Furthermore, the issue of economic disparity within marriage, particularly in an era of widening income inequality, demands greater attention. Divorce laws must ensure that both spouses, regardless of their earning potential or contributions to the household, are treated fairly and equitably in property division, alimony, and child support arrangements. Despite these challenges, the evolution of divorce law also presents opportunities for positive change. By moving beyond the adversarial model of fault-based divorce, lawmakers can create systems that prioritize conflict resolution, mediation, and collaborative solutions that minimize the emotional and financial toll on families. This includes expanding access to affordable legal aid, counseling services, and parenting education programs that equip couples with the tools and resources they need to navigate the complexities of divorce with greater understanding and compassion. Ultimately, the future of divorce law rests on our ability to embrace change, challenge outdated norms, and prioritize the well-being of individuals and families above all else. By fostering open dialogue, promoting healthy relationships, and creating a legal framework that is both just and compassionate, we can help ensure that divorce, while never easy, can be a pathway to healing, growth, and new beginnings. Section 1. The enduring debate, no easy answers, only thoughtful considerations. The question of whether states should ban no-fault divorce is not one with a simple or universally satisfying answer. It's a debate woven from complex threads of individual autonomy, evolving societal norms, and the enduring significance of marriage as a social institution. As we've explored the arguments for and against no-fault divorce, delved into historical context, and examined real-world implications, it becomes clear that there are valid concerns and compelling arguments on both sides. Those who advocate for a return to fault-based systems often do so from a place of genuine concern for the sanctity of marriage. They worry that the ease of obtaining a no-fault divorce undermines the commitment it represents, potentially leading to a devaluation of this vital social institution. They see marriage as a bedrock of society, essential for raising healthy children, fostering stable communities, and transmitting values across generations. Their concerns about the potential for increased divorce rates, particularly hasty or ill-considered separations, are not without merit. However, it's also crucial to acknowledge that forcing individuals to remain trapped in loveless, unfulfilling, or even abusive marriages serves no one's best interests, least of all any children involved. Denying individuals the autonomy to make choices about their own lives and relationships can have devastating emotional, psychological, and even financial consequences. Furthermore, the fault-based system, despite its intentions, often fails to achieve its stated goals. Proving fault can be a costly, time-consuming, and emotionally draining process, often exacerbating conflicts and creating a hostile environment for all involved, particularly children. The subjective nature of fault itself raises concerns about fairness and consistency, as different judges and juries may interpret the same actions in vastly different ways. The pursuit of evidence can become an intrusive and destructive force, undermining trust and privacy within families. Moreover, the fault-based system often disadvantages the most vulnerable members of society, particularly women who may lack the financial resources or social support to navigate the complexities of proving fault. As we grapple with these competing perspectives, it's essential to remember that there are no easy answers, no one-size-fits-all solutions. Embracing compassion and fairness. Focus on creating a future where marriage is valued for its fulfillment and equity. Promote understanding, communication, and conflict resolution. Invest in premarital counseling and relationship education. Ensure the legal process of divorce is fair and accessible. Address power imbalances, especially financial. Reform alimony laws for better support. Check out my YouTube video, Divorces in North Carolina, Sandra Dinkins' Justification for Separation Pay and Alimony. Ensure adequate and enforced child support. Promote shared parenting for children's best interests. Recognize diverse family forms and craft inclusive laws. Embrace a compassionate understanding of marriage and divorce. If you got value from this video, please subscribe.